Okay. All right. Well, hello everybody. It's very nice to so much for giving up some of your busy time to spend that with us here today. This is our annual LexisNexis event. We're here in Sydney. This is our fourth time around. So this morning we were in Brisbane. Last week we were in Canberra and Melbourne, on to Perth and Adelaide next week. And this is the fourth year that we've run this event series, with the aim really of facilitating discussion in the legal services community. This year we're looking to uncover perspectives on the current impacts of technology, including AI, and what we see as a really rapidly changing legal industry. And in fact, within our organisation, we talk generally about the fact that technology is going to change the legal services industry more in the next 3 years than it's changed in the last 30. Many of you, I'm sure, will know LexisNexis already, but please indulge me for a few minutes whilst I tell you a little bit about our organisation. We've been in business now for over 200 years in one shape or form globally, and we have a long-standing history of innovation within the legal industry. Traditionally, I think you would know us as a provider of legal content, but now we are fast evolving into an information analytics and decision tools business. And indeed, I just returned back from the Silicon Valley in the US, where we had a senior leadership conference, where we feel we really have an established place, sitting alongside Silicon Valley entrepreneurs that are really at the bleeding edge of what's going on in this space. And as time has gone by in the industry that we serve, we've seen the way in which lawyers utilize content has changed quite a lot over this time. First, the obvious transition from hard copy to digital and other online forms. But now we're really seeing other changes take place, where there's really more complex demands upon content and data that we think offer some really rapidly evolving possibility. In the US, our organization acquired businesses such as Lex Machina, Ravel Law, and IntelliGize, which help us extract quantitative insights from huge data sets to provide lawyers with the information they need to make decisions faster and more effectively than ever before. And in Australia, we also have developed off-the-shelf data visualization and analytics solutions like the High Court Analyzer or Court of Appeal Analyzer. But we also see demand for more customized analytics solutions fast emerging that harness the power of our Australian content to quickly surface connections and information for intelligence, litigation, or commercial insights that would otherwise have taken hours and hours to pull together. Many of you will know our Lexis Advance platform that surfaces more data, believe it or not, than everything that you would find in Wikipedia, and is enhanced regularly, as any good software platform should be, with incremental improvements delivered now every few weeks. And these enhancements are supported by an ever-growing similarity, meaning the information you need is more accessible and with you faster and more easily than ever before. So we're changing rapidly, but we're only one player in this space. And there are countless legal startups, firms and organizations of all sizes that are making waves in our industry. And indeed, you might be interested to know that there were 787 legal startups globally in 2018, 36 of which were in Australia, and that compares to only 17 globally in 2010. So you can see how fast things are moving. So it's exciting to be part of the conversation. We're really looking forward to that happening today, and hopefully you will find some real value in the next hour and 15 minutes or so as we share the opinions of our panelists, but you'll also have the opportunity to give us your opinion and questions as well. So before we get underway, a bit of housekeeping. The toilets, if you need them, are out of the door and keep going left towards the lifts there. If you want to use Twitter, you can today. We have a Twitter there, #AI2Ethics18, which you can see there at the bottom of the slide, and by all means do Twitter. I see Ed, you're already getting your phone, so there you go, have fun with that. And before we get started, let me first take a moment to introduce our panelists that are here with us this afternoon. So if you could hold your applause for the panelists until I go through the 4 introductions, that would be fantastic. So first on my left here, Brenda Tronson, who's a barrister at Level 22 Chambers. Brenda represents a range of clients, corporate, government and individual in a variety of courts and tribunals. Before starting at the bar in 2008, Brenda worked for Freehills in Sydney and as an associate in the High Court. Brenda has held a number of executive committee roles, including secretary in 2013 and executive councillor in 2012 of New South Wales Young Lawyers, amongst others. And adding to her accolades, Brenda was named New South Wales Young Lawyer of the Year in 2010. Next to Brenda is Erika Ly. Erika is the New South Wales President at the Legal Forecast, which is an organisation that brings together a community of law students and legal professionals who are passionate about advancing change in the legal profession. Prior to this, Erika was at Techno-Legal at Gilbert and Tobin, and she is a strong advocate for advancing the update of technology within the legal sector, and has thus co-hosted and organised the Global Legal Hackathon in Sydney. Next to Erika is Aaron Taranto, who is an in-house legal counsel at QBE Insurance. Aaron is a commercial lawyer and business designer with a passion for innovation and digital. In his spare time, Aaron designs websites, brands, and strategy. And by combining these professional and creative disciplines, Aaron aims to create value for new and transforming enterprises. Prior to QBE Insurance, Aaron worked as a litigation lawyer at Great Walsh. And then finally, at the end there, Dominic Woolrych, who's the Chief Executive Officer at LawPath, which is Australia's largest and fastest growing online legal platform, helping over 50,000 Australian businesses access legal services. Prior to LawPath, Dominic was a corporate lawyer at Minter Ellison Lawyers in Australia, and Dominic spent time at the Public Interest Advocacy Centre as a criminal solicitor and at the International Court of Justice. So please join me in welcoming the panel. All right, so just to get us started, we have a really short video to introduce a couple of things.
This has something to do with my kids.
Look at what happens to your son.
My son? God, he looks just like me. Within 2 hours of his arrest, Martin McFly Jr. was tried, convicted, and sentenced to 15 years in the state penitentiary. Within 2 hours?
The justice system works swiftly in the future now that they've abolished all lawyers.
Man,
Or it gets worse. This week's order attempts to break him out of jail. She gets sentenced to 20 years.
my daughter. Wait, I haven't taught.
So back in 1989, when they made Back to the Future 2, Doc Brown was referencing a world in 2015 where there were no more lawyers, but there were Hogwarts. But in 2018, I think we can agree lawyers are far from being abolished. And as AI and automation makes inroads into legal services, perhaps the way lawyers work is changing more than abolishing lawyers altogether. And as these changes are apparent, they also come with quite significant, we believe, responsibility. Ethical questions related to the growing use of technology abound. As tech becomes more complex, so too will its relationship with people, and new rules may need to be developed for this frontier. So over the next hour or so, we're going to explore a number of these areas, including data protection and things like algorithmic bias. And we've got a lot of ground to cover, and we appreciate we might be just scratching the surface in some of this discussion, but we'll endeavour to do the topics and our presenters and panelists justice, and I'll make sure that we get finished on time. So as we just get underway, a couple of points to mention. We're going to be live polling through the hour or so today. So for you, those of you that haven't done this, this is the time where you need to actually grab your mobile phone, and you can help by participating and answering questions as we go today. You okay, Max?
Yep, all good.
Always worrying that I just wondering up the front. Thanks, Max. So grab a browser and then enter the address there, poll.ev/LexisOz. You don't need to log in. If you're prompted to enter a screen name, you don't need to do that. You can absolutely stay anonymous. And this will help you respond to a few questions as we go through the day, which obviously will be around the discussion points that we enter into. But as we also go through the next hour or so, we are absolutely ready to answer any questions from the floor. So as we dive into something, if you have a question that you really want to ask, please raise your hand or shout out. We can make sure we get a mic to you. But there will be time for questions at the end. And indeed, we're trying to leave at least 15 minutes for that session. Okay, so let's kick off. Erika, I think I'm going to go to you first for this question. So we really want to just talk about the reality for young lawyers. and really what's happening right now in that space, and perhaps a view out in the next kind of 5 or 10 years or so. Do you think technology is creating opportunity for young lawyers? Do you think it's making it more difficult for them? You know, what's your view of that particular space?
So I think the view of technology, what usually kind of happens is that when you have a technology that kind of impacts a new industry, there's a lot of people that kind of get afraid of it, they're not really sure what's happening. And this is also, I think there's a lot of opportunity for lawyers and young lawyers who are actually interested in this space to kind of explore new options in technology. So my job, for example, at G&T as a techno-legal was one of those kind of hybrid models that created new opportunities for young lawyers. But I think there's a whole bunch of different skills that can come into the legal industry, and a lot of those are not necessarily strict kind of legal skills. So you can do things in that continue around customer experience. You can do things to do with legal technology. You have data engineers, and there's a whole bunch of opportunities for lawyers who are actually interested in this space. But so long as they kind of look outside what is traditionally the scope and the traditional kind of scope of the legal pathway.
Okay, thank you, Erika. Aaron, I might throw to you on this one. What are your thoughts about the skills of young lawyers?
I guess for the first time in about 6 years, I'm probably excited about my career in the law. I feel like some of my investments in tech have finally started to pay dividends. I guess I've got two views. I think one, there needs to be more lawyers with tech skills and significant tech skills. I think universities need to teach computer science and law. And if we did that, we would open ourselves up to a whole new field of innovation. And I think that, I don't know, I think that we're still 5 to 10 years off significant disruption in the industry. I was talking to Dom before. Obviously, I work for a large insurer, so we have a big interest in insurtech at the moment, and there's literally hundreds out there. Someone put up a slide full of logos just last week, and I can't really think of the same amount of sort of innovation happening in this what I'd call law tech space, although Dom probably knows more about that. So for me, I think young lawyers are great at problem solving, at creativity, at thinking outside the box, and finally, I think the industry is starting to come around to how commercial and needed those skills are. So I think if young lawyers start to focus on these sort of more abstract concepts of how they can produce outcomes, we'll be on a good step.
Thanks, Aaron.
I have a response to that actually. Just on your point about legal education, there are actually combined law degrees, combined IT law degrees. I think the only thing is that you only have, I know we don't have any at the university. There was about 7 from UNSW that graduated last year. They're actually incredibly rare species. But I would also say that I think a lot of the universities are actually really pushing for law and technology courses as well. So you do have that coming from the universities mainly because the students are kind of asking for it as well. So it is coming through. It's just a bit of a slow change.
And I guess you got 2 languages. If you know coding and the language of the law, bilingual really.
Yeah.
Thank you.
Yeah, I think it seems a little bit doom and gloom for new students coming out of law school these days. We read all the articles in Lawyers Weekly saying there's oversupply of law students, there's 15,000 graduating this year, there's only 75,000 lawyers in Australia. Where are they all going to go? And I'm very much going to echo what the others have said, which is law students must think outside the box. There's not that the old path, which is heading to a top tier firm and becoming a partner. Obviously there's students out there that want to do that, but I think law students really need to understand that there are so many opportunities out there now. 700 legal startups in the last couple of years, they're all looking for young, creative people to join those companies. So yes, it might seem like there's an oversupply of lawyers and law students, but if they start thinking about where they can go be placed in a corporate or where they can be placed in a legal tech company, it's actually a really, really exciting time to be a law student.
And sorry, Brenda, go ahead.
Sorry, I just want to add 2 points to what has been said. One is that in Australia, only 50% of law graduates have worked in law for a very long time, and that, of course, is the strength of our combined law system. I'm not sure what the numbers are in terms of whether more people are now doing the JD or graduate programs compared to 15 or 30 years ago, but nevertheless, for a very long time, 50% of law graduates have not worked in law by choice. So I don't actually see a problem with that continuing, because there's a really huge value in having people working in all sorts of areas who've got some kind of legal literacy. The same with lawyers having technological literacy. The problem I see, however, that we might need to control or control for as technology becomes a more important part of the way we do law, is that one of the things that's going to go first are the routine and drudge type tasks. And so, in fact, we're already seeing them go. We have seen some of those go already, like discovery being a big one. The issue there, of course, is that's how many lawyers learn not only how they maybe get into the profession and get a job, but how they start to see how law works from a practical point of view, and then they build up their other skills from there. So my big concern, I agree, it's a really exciting time to be a law student or a law graduate, particularly for people who've got an interest in and/or a background in tech. But we need to make sure that we're ensuring that the people who want to go on to be lawyers, as opposed to a hybrid role or a tech role with some understanding of law, that the people who want to go on to be lawyers will be able to get that background, whether it's through some other kind of routine task or ensuring that those of us who are more senior are mentoring people in a more deliberate way.
And sorry, Dominic.
Yeah, I mean, I think there's other ways to educate the lawyers other than just routine tasks. So, I think especially junior lawyers are going to move from becoming lawyers to more like legal analysts. We hear Erika used to be a techno-legal, at LawPath, we call them legal engineers. These are younger lawyers that are learning to analyse and read reports that software is helping them generate. So I kind of would push back a little bit on this idea that without doing mundane tasks, they're not going to learn the law. Maybe they're just going to be doing it in a different way.
Oh, absolutely. My point wasn't without that, where do they go? It's without that, we need to make sure there is something to replace it.
Sure.
And interestingly, you mentioned graduates there a lot. We talked about tech and obviously legal language or knowing the law. Are there other skills that are there? I mean, project management gets talked about quite a lot as a skill, and in a way that now, I guess this idea of working in cross-functional groups or working in a wider, in wider kind of groups to practice or to be effective is now important. Anyone like to comment on that, Aaron?
Yeah, so I mean, obviously digital design, UX design, as well as coding, graphic design in general. I've had an interest for the past 10 years in digital design, graphic design, and the crossover there with brand worth, trademarks, and really developing a company to be well recognized. So, and simply don't underestimate the value of a good slide deck. I think young lawyers can really, if as Don was saying, even if they don't know the law per se or how to get to a legal conclusion, if they can recognize trends and start to understand data and how opposing sides might work and how a judge might come up with his reasons, then they can really talk to particular topics and give a viewpoint which is different. And if you combine that with other skills, you're going to create opportunities for yourself in the future. So, I love my job at the moment because I get to work with a whole bunch of different teams, digital teams, project managers, customer experience, and because I know about these other areas, I can really have meaningful conversations
Let's move into another section now. We're going to talk a little bit about the professional responsibility of a tech-driven lawyer or a lawyer obviously working in this kind of changing industry. Whilst we make that transition in this space, I'd just like to ask a kind of an open question, and anybody please jump in on this. What do we see as the most, potentially the most disruptive technology that's really coming through? And the reason I asked that question is we asked that question a year ago in this session, and there was a very clear answer that came quite consistently around that. I'll tell you what that is in a minute. Somebody might be able to guess it. But what are your thoughts now about this level of disruption, or what the technologies are that are really going to disrupt?
In law or generally?
In law.
So I'll jump in first. I think the answer's probably on the screen up there, which is AI, and especially around neural networks. So this idea that technology or a certain software can actually replace a lawyer's reasoning. I think we see a lot of technology out there at the moment that can replace the mundane tasks, it can do automation, it can do repetitive things. But down the track, we're looking at things that can actually reason. You mentioned a company before, Lex Machina. For people who don't know, this is a US company that LexisNexis is involved in. It's in the IP space, and essentially lawyers or clients can go into this software, plug in the details of their case, and it will actually come back with a percentage of who it thinks will win. And so that is actually replacing what a lawyer does. So I think what's really interesting as the company gets older is that we're starting to see that they will never replace a lawyer completely, and that's because lawyers are always going to be needed to do the client interaction. When we started LawPath 4 years ago, we said we're going to replace lawyers. We watched Back to the Future and said 2015 they're all gone. And fortunately for all the lawyers in the room, we've realised that we're never going to be able to replace a lawyer. We might be able to replace the repetitive tasks that they do. We might be able to even replace some of the reasoning that they do, but we'll never be able to replace the client interaction that a lawyer has, and actually explaining those results to a client. So I think probably the most disruptive technology would be something that can actually replace that part of the law.
So, yeah, I agree. I just put it different words to it, which is predictive analysis. As I understand it, the Netherlands are probably, together with the US, at the forefront of this. They developed a solution for family law where partners could plug in their contributions and it would give you an outcome. And you can accept that outcome and settle on those terms, or you can appeal that decision and go before a judge. And I think they're now opening that up to different areas of the law. And I was having a conversation with Dom about this. I think as we move forward and as competent lawyers who understand the nuts and bolts and can develop basic if-then statements for tech, you can really get some sort of prediction as to what is going to be the outcome there. And if we start small and we start with simple matters, we're going to get to very complex things sooner or later.
I would also agree that the answer's kind of on the screen in terms of the AI. But I think neural networks, predictive analysis, what I would call as predictive analytics, but it's also what we kind of see as kind of stage 2 AI. So I think in artificial intelligence, you talk about different kind of stages of AI where you have things like document automation and you have your kind of low-hanging fruit that you can actually automate, which is why the law paralegals are terrified, and so the e-discovery kind of stuff. But where it does get interesting is when you get to the stage where you can actually aggregate mass kind of amounts of data that spit out results. But I think there's also been, the interesting thing about that, and goes to your kind of statement, Aaron, is that when you have lawyers that can code if this then that statements, that is actually kind of coding your knowledge into the actual technology or the actual system that you're using. I suspect we'll talk about algorithmic bias in a bit, and I will actually leave it at that because I'll save my points for that.
All right.
In the long term, if we get there on AI or stage 2 AI, then I agree that would be absolutely the most disruptive. In the shorter term, in terms of what's happening at the moment, I think the most disruptive technology from a legal point of view is machine decision making, particularly in relation to government decision making, and the question of who is the decision maker if a machine is making that decision. It throws up, not only in an area that I do quite a lot of work in, admin law, it throws up some really interesting admin law questions about how do you review a decision that is made by a machine, but also questions about power, which are absolutely fundamental to government and governing. So that is what I see as the more short-term disruption. I also just want to address something that's assumed, I think, in terms of talking about what is the task of a lawyer and the idea of predictive analytics, or whichever term is used. I'm not sure that the only task of a lawyer is to predict a result. I agree it's part of it, it's part of the process of giving advice, but certainly whether you're talking about transactional work and drafting a contract, or certainly when you get to my role and doing the advocacy, part of our task is to try and avoid or change an outcome. Maybe I can say, look, you've got about a 15% chance of winning this, but I can do a really good job and get you a 20% chance. It's still pretty low. You can take the risk if you like. And that, I mean, I think that ties in, Don, with what you were saying about the soft touches and the client approach, which certainly at this stage can't be replicated by machines, but with what some people in Japan are doing with nurses, maybe we'll see something with lawyers. But the other aspect, of course, with advocacy is the persuasive aspect. And while we have human decision makers as judges, coming back to the decision making, I think we will also have a role, fortunately for me, for human advocates. So that will take a little bit longer, I think, to replace by machines. But when we replace the judges, maybe we'll go as well.
I mean, keep moving on, because I know we've got a lot of materials covered. No, that's quite all right, Brenda. Thank you for that response. And I think it leads us really nicely, actually, into the next kind of section of this piece that we're going to talk a little bit about professional responsibility and understanding of technology, which I think obviously is linked very much to that decision-making power. We actually have a poll question here that we'd like to ask you. Interesting enough, in 2013, the American Bar Association revised their ABA model rules of conduct to state that lawyers must be tech savvy in order to provide a competent representation to a client. So it's kind of interesting in terms of this idea of really understanding the technology, and is there a real professional responsibility to understand the technology, or what level do you need to understand the technology in order to represent in the way that you should. Again, Aaron, do you want to respond to that particular question?
It's a resounding yes from me.
Yeah.
I mean, so just to go back to the point of AI, I was reading an article recently which said, AI is really just machine learning, and machine learning is just really a lot of data and understanding that data. So, not only do we have a professional responsibility to understand tech, we also have the opportunity to, what this article called, be the machine teachers. So to tell the machine how to treat that data and what to do with it, which is just going back to the point that we were on before. But I don't see how anyone can have a job that is lucrative without being good at tech. Everything is online, everything is connected, and by the very nature of the way that the world is going, at least Office 365. I spend a lot of time at work reformatting documents for some of my older colleagues. And that's on its basic level, and everyone can do that, but there's some really, really amazing things that you can do if you really understand, how things connect.
Thank you. And I mean, and our poll there quite absolutely kind of supports that piece in terms of understanding or our professional responsibility to understand the technology. We'll move to the next question, which is really about transparency in technology. So chatbots exist. They're out there everywhere. In fact, I'm sure we've got one in our business, or 2 or 3 in our business somewhere. Chatbots, it would seem, I think, are somewhat supported, notionally in providing legal information. But are we in a world where we would trust the technology enough that chatbots would be able to deliver legal advice, and that we would see it as being potentially sound? Dominic, do you want to jump in on that?
Yeah, I'm happy to answer this one. I built a chatbot last year, so I can tell you my experiences, and I think the room would agree with my answer, which is we're not quite there yet. So just to give you a little bit of an idea, we partnered with a company called Ibm Watson. They have built a platform, and one of the features on that platform, it's an AI platform, one of the features is the ability for natural language processing and to build a chatbot. So what we did is we fed in all the domestic violence legislation in New South Wales into this data room, or this data set, and the user or the client could have a natural language conversation through a chatbot with this data set, and it would pull out whether it thought domestic violence was present or not. Now, obviously, doing that type of exercise, the chatbot didn't have or wasn't complex enough to actually provide a definitive answer. But what the chatbot did as a result was then point the user towards a drop-in centre or a help centre here in New South Wales where they could get help. And so you might think, well, it's not giving us the ultimate answer whether domestic violence is present or not. Why build it? And the reason was that for a client or for a user to drop into one of these centres is quite intimidating. So this was really a first step for them to do it at home, where they could interact with technology. Now, it wasn't going to give them legal advice, but it was going to point them down the right path. So I really think with chatbots especially, they're a really good interface for us to start conversations or to start a process that ultimately ends with a lawyer giving you advice.
Okay. Erika, do you have a comment?
I was also going to say that I think, so one of the cool projects that I worked on was that we had the Harper Review come out, which is to do with competition and legislation and changes in that. And it was a very similar thing, is that you can't necessarily code all the, I remember actually, because I was working with a partner, and basically we're trying to create this tool for, basically trying to kind of create a tool that would assist the client to kind of get to the answer, but then having kind of to read the 60 kind of page document of all the various scenarios, I remember taking kind of big red pen and just crossing out a lot of those, and this other kind of poor graduate had spent the last 2 weeks working on it. But just the headings, because they're actually the most important things that any client would need to know, and it's a really good triage solution. So at the end of the day, you're always kind of talking to the lawyer, and it goes back to that very human advocacy, you're serving the client kind of aspect, because technology can certainly help you and assist you do the things that you do, but faster. But it still requires you to be present.
Okay, thank you. All right, let's switch gears again now. We're going to talk. Oh, sorry, I will comment first on the screen there, because we see some interesting results. I mean, I think this depends on the matter piece. It's actually been consistent with what we've heard from the audience members as we've gone around the country. But it is quite interesting here that there's quite a strong feeling that bots can never administer sound legal advice without human supervision, and that's a little different than what we've seen around the country. And certainly, that is a notion of trusting the technology, the transparency behind it. Can bots or can the technology really pick up contextual nuance and those kind of things, which I think is fascinating. But in terms of scaling across the surface, let's move into another massive subject area, and that's data privacy. So, obviously this has really received a lot of media coverage recently. It's a topic that I'm sure everybody's incredibly aware of. Data breaches are now, it's seemingly a kind of daily occurrence that we hear about data breaches, scandals like Cambridge Analytica, for example, but recent media campaigns around things like My Health Record, as an example. November the 15th for people that want to opt out, by the way, just later. But we can be kind of frequently unaware, I think, what is happening with our data, and what is being stored and how that is being used. of course, there are pros and cons. I mean, the flip side of it is that the benefits of AI, particularly things like machine learning technologies, we have to start becoming comfortable with a certain amount of data being available and being used in order to have that AI be fully functional. But then there's the question of consent, which also then takes us down to into a big area. Brenda, I might throw to you on this one. What are your thoughts about this particular space?
I'm going to just do a bit of an all-star poll here. Can everyone please put up your hands if you've got an Opal card? Okay, keep your hand up if it's registered. That's about 50%. You may or may not be aware, thank you everyone. You may or may not be aware, but there was a case in the New South Wales Civil and Administrative Tribunal decided a couple of months ago, where someone who had a pensioner's Opal card, so in order to have that, you may be aware you have to register, you can't choose to have it unregistered, made a complaint ultimately to the tribunal, but through the process under the relevant legislation, that his data, his personal information, particularly his trip information, where he was at a particular time and so on, was being collected by Transport for New South Wales and should not have been, but this is a breach of the Privacy Act, and he won. I think it might be being appealed, and I haven't heard what's happening with that. I wasn't involved in that case at all. But what I find really interesting about that is it's a very good example of something that we were discussing a little bit before everyone came in as well, of where the tech people build a system that collects a whole lot of information because we can. People are going to pass through the Opal gates, they're going to swipe their card, we can collect that information, so why not? And the answer to the why not is because maybe it's a breach of the law. There's a very good article by a woman named Brenda Johnson, who runs an organisation called Challenger Privacy, on this case. So if you're interested in reading more, I'd suggest Googling Anna Challenger Privacy and having a look at her blog post. It's written in a very accessible way, even if you don't do a lot of privacy law. But the main point that she makes is that we really need to be building in design for privacy protection as part of the way we design any technological solution that can potentially be picking up data. I think that's really what I see the GDPR is all about, providing a legal reason for organisations to do that. And it's also what we see, or the absence of that kind of planning or design is what we see behind a lot of the big data breaches that we've seen over the past couple of years.
We might ask the next question as we go, because I note that Brenda brought up the GDPR, which is really obviously the big privacy piece that's happening kind of globally. I think May 2018 that came into effect. But do we have the right kind of privacy protections here in Australia, and particularly in this idea that you're giving consent now, maybe you're not, but as technology evolves, does that consent still, is that still relevant? Not knowing how that technology will evolve and use that data. Erika, you were gonna just jump in on Brenda's comment. I think that's I didn't want to come in.
I was going to jump in on Brenda's comment, and I think I was just saying. I know Aaron and I were speaking earlier about design thinking, and it's that idea where lawyers are kind of tacked on at the end, right? And I think that's why sometimes you have this characterization of always saying no, always thinking about risk, always thinking very conservatively. But I think if you actually have a lawyer that works, and it kind of, we'll need to change the model a little bit, but if you have a lawyer that actually works with the ITs and the engineers at the beginning of the process before you actually develop an application or a platform, that is actually an incredibly valuable bit of input where you actually do design in data and privacy protections to then later, in a way, and I'll get some shakes in the head, but to kind of future-proof that particular piece of technology from any kind of sort of risks down the line, and you're kind of looking out for problems before they actually occur. There's few people and few lawyers that actually understand, like if you have a data and privacy lawyer that does work with IT people and engineers, that is a very kind of rare species, because they'll have to understand both languages, as we were talking about earlier. And I think there's an immense opportunity for any lawyer who's interested in that space.
Yeah, I'll just tack on from there. So I think privacy is a really interesting space at the moment, and particularly data packets. I had a housemate last year who I think everyone would know is as the crypto guy. So we had a lot of discussions about blockchain, smart contracts, and data packets. And I'm not sure where the Parliament is up to in terms of this legislation about being able to obtain your data from banks and transfer it on to another institution and so forth. But that's sort of certainly the concept around the GDPR. Whether someone will commercialize that and where the profits sit there, I'm not sure. I think there's a big opportunity there. But I think that data really, I'm not so concerned about Facebook or Instagram or anything like that. Technology by its very nature tracks you. Your Opal card tracks you, what you buy at Woolworths tracks you. That's only as valuable as those organisations want it to be. And really the compromise for having access to free services like Facebook or Instagram is that you are consenting to them having your data, and the option is to delete it. And there's costs and benefits to both. I'm fascinated by a guy on the internet at the moment who actually heads up the innovation team at Microsoft and is one of the founders of VR. He's a very strange looking guy with long dreads. His name is Jaron Lanier. If you want to Google him, he's got some good TED Talks about how we need to remake the internet. And he suggests that, even though Microsoft owned LinkedIn, he says delete all of his social media accounts because the economic detriment is so severe, and all you're doing is giving profits to these massive computers. And so he argues that we need to fundamentally rethink the way that we contribute to the internet and who we give our data to and why we're doing that.
Thanks, Aaron. Okay, we're going to move into another section now, in the sense that I want to make sure I give the floor the opportunity to ask questions. I'm just going to introduce our last kind of topic area, and then we can jump around a little bit together. And this is this really idea of algorithmic bias, and we spoke a little bit about this earlier on. So there's a book called Weapons of Math Destruction by a Harvard PhD graduate and data scientist, Cathy O'Neill, where she makes the point that algorithms are just opinions embedded in code. And she rejects the idea that mathematics is objective, instead arguing that mathematical models serve to replicate biases and frequently reinforce discrimination. And I think she's got quite a compelling argument. I just invite you to do this if you have 2 minutes at some point. Just Google 3 white teenagers, and then look at the images that you get there when you Google that phrase, and then Google 3 black teenagers, and then look at the images that you get there as well, and you'll see what I mean. So the fundamental idea of algorithmic bias is an algorithm is fed biased training data, which learns, and then the algorithm learns to kind of reinforce those biases. And remember, algorithms are being used all the time now, and they're being used in our space. They're used to assist with decision making around the risk of things like recidivism, bail decisions, criminal profiling. And we're seeing mixed results in that arena. Critics say that it really just reinforces bias. Proponents say it removes subjective human reasoning and brings greater consistency to decision making. I'm going to go to you there at the end, Dominic, on this one. What are your thoughts about algorithmic bias, friend or foe?
Well, the good thing for the legal industry is that we're not the only industry facing this problem. There's bias across all algorithmic bias. I think one of the unique problems that the legal industry has is that really to train this software, we need data, we need data sets. And lawyers in the legal industry are in a situation where we don't really have access to too much data. And that really comes down to our kind of professional obligations around confidentiality. What we see in other industries when they're looking to combat this problem is that they'll put huge data sets together, and the more data you have, you can combat that bias. where are we going to find 3 large law firms that all want to put their client data together and actually do that? So I think that's an issue we have, and I think probably the way to get around that is we'll start looking towards some of the legal publishers, because they're actually the ones that hold huge amounts of data in the industry, and those are the type of players that will be able to combat that through using the data sets.
Okay. Brenda?
Just in terms of what that data set is, though, of course, that data set precedents, authorities, cases. And one of the issues, talking about change, moving away necessarily from just technological change, the idea of the common law system, of course, is that we not only can have consistency and say, this case should be decided in this way because that is the way all other cases have been decided, but we can also say, oh, hang on a second, this is a new situation. We need to develop the law further to deal with this. And so I do wonder if, and again, Dom in particular, but I think all 3 of you would know more about the capacity for that sort of decision making to be done. But I do wonder if it might stifle change in new situations in a way that at least theoretically, the common law decision, the common law process allows for.
So, yeah, I mean, I think that's why this industry is going to be slow to change, but when someone figures it out and figures out the capabilities to do it, it will probably be severe. So, I mean, you know, to Dom's point, you know, you can get a lot of that data from, as Brenda said, from cases, but the process of reverse engineering that case to extract the facts, extract the circumstances, extract the legal principles, and extract the way that the judge has applied that to the certain circumstance, and then take that on a mass scale and understand what the trend is in the Supreme Court in a particular jurisdiction. You know, that takes a significant amount of legal knowledge and a real breakdown of you know, fields and parameters and what questions do you need to ask for the input to get a particular output. And what are the algorithms in the middle that can do that? So, and then, you know, as we were saying before, if you get a percentage, is that first percentage, you know, inherently biased? Well, it depends on, as I was saying before, the machine teaching. So, you know, can you come up with multiple outcomes? Do you have to rank them? Yeah, I find it fascinating, and I think there's just so much potential here.
And I think there's actually a case on point. You guys can look this up. It's called Wisconsin and Loomis, and basically what it is, it's a case that happened in the United States Supreme Court, and they kind of coded a whole bunch of bail decisions that happened in the last 30 years or so. But what also happened in the last 30 years or so was the United States civil rights movement. So what ended up happening was that you actually had coded bias in the system against African American people, right? But it goes to the point where you have what we kind of say a lot of the time is when you have garbage in, you also have garbage out. But what a lot of people do forget is you can actually, there's different stages of when you deal with AI, and I think it's a bit more of a nuanced understanding, but you have your information kind of gathering level, right? And that's to deal with your different parameters of what data sets you use, what kind of categories you classify things into, and then you have your training level. So it takes people to understand whether you have the right targets or standards that the AI machine is kind of looking for, right? And so you actually set those targets or standards. But of course, the last kind of level that we always need to remember is how you continue to adjust for those variables slightly. So when you do have cases that outline what is traditionally precedent, you can kind of pinpoint why and constantly revise, because when you're building technology or when you're building machines, is that they require constant examination and constant re-examination. You don't just kind of build a system and then leave it, because that would just be irresponsible. So it requires that constant thinking and that constant evaluation of how well the system is doing and understanding the data that goes in and also the outcomes that come out of that.
Thank you. We're going to go to our last question now, because I think this touches, this idea of transparency, trust, equality, fairness, and how technology works in that space. Big question. If you're interested in trying to determine or being part of the discussion, LexisNexis is actually involved with the Human Rights Commission in this space, and there is a policy paper being developed in the next couple of years in this arena. And it's this question, does AI really pose a threat as far as human rights are concerned? Let's end there on that question for a couple of panelists, and then we'll go to questions. So who would want to jump in and respond to that? Brenda?
Doesn't everything pose a threat to human rights? But also, to be a little less cynical, all AI is just a tool. So yes, it poses a threat to human rights because there are ways that it can be used that undoubtedly will infringe rights. But it also seems to me that it must be a tool which could be used to protect or promote human rights if we go about it the right way.
Yeah, absolutely. Any other comments from the panelists? Aaron?
Yeah, so I agree with that, and I think the entire flavour of what we're saying up here today is that all of this is going to require human oversight for a very long time. So, I think we're safe for a while still.
All right, so the robots aren't taking over quite yet. Let's just open the floor.
At least it's not any worse than we are.
Well, that's true, maybe. So let's open the floor up for questions. We have about 10-15 minutes where we can certainly respond to any questions that anybody has. Yes, sir, at the front there. Andrew, I think there's a mic coming to you.
Thanks, Al McCabe from Sydney Uni. One question I had is, I wondered, I heard some urgings about the way law schools should change and legal education should change. Have the panel got any predictions about the popularity of studying law in light of some of the issues? Like some prospective law students might start to think, well, I'm going to get disrupted and I'm not going to do a law degree. So I wonder what the panel think of that.
I can speak to this. So it's really interesting because in my team in New South Wales, we have someone who graduated about 5 years ago. We also have one of our youngest team members is just turned 18. Her name's Ivy. She's a weapon of the human. And I think you think about the generations that are actually coming through, and I think about my generation as being the first generation that grew up with the internet, and that's pretty big. You have all the access to information at your fingertips. You can Google anything that you want. I can learn how to play the ukulele in about 2 weeks. Like, these are things that you can kind of go and go out there and learn. I think there's a huge interest from young people about this in this space. I mean, that's the core reason why the legal forecast came about. It was a bunch of frustrated law students who are now lawyers, wanting to engage in this idea of technology and legal innovation, but we weren't able to access these kind of events. We weren't able to access what was the things that kind of that a lot of the professional associations kind of put on, and so we created our own. And I think that in itself, and we've grown in so fast in the last 2 years, last 18 months. And I think that is an absolute testament to young people wanting to kind of learn and know more about this space, but not necessarily knowing where to look. I think with the universities, you do have a couple of, Griffith John Flood, he's recently at university, they're coming out with law and technology courses. You have one at UNSW that does in neurologic. Monash Melbourne recently announced one. I think there's huge interest for it, but I think with that you do have a limitation with pre-C 11, which is a bit of a shame. But and I could definitely rant on more about that. But there is an interest there. But it's just what to do with that and how to kind of push that through the universities.
And just to add one point to Erika there, I think obviously it's important that these universities start doing these majors or focusing on the technology, but it shouldn't be at the detriment of the pre-C 11. There still needs to be that core foundation that you learn in law, because there's a lot of hype around legal technology at the moment. And look, that might continue or it might die away. You know, I wasn't around, but in the 70s I heard there was a lot of hype about expert systems in legal. So I think it's really important, obviously, to focus on what's happening currently, but not at the detriment of core legal studies.
Yeah, I mean, I think universities need to sort of fundamentally rethink the way that they deliver law. You know, when I started as a grad, I felt like I knew nothing, even though I'd done exceptionally well at uni, and that's because the practical and the everyday skills had sort of not being taught, and the broader principles have been forgotten. So would I tell a young person to go and study law at the moment? Probably not. I'd probably say, go and get some commercial skills, go and get some tech skills, and then think about it later in life, because it's really hard, it's really expensive, there's not many opportunities, there's opportunities that are going to be less, and there's going to be less training. So I think that it just needs to be a real rethink about the entire delivery of it.
Can I add one more point? Is that it also deals with the whole rethinking of what a lawyer is, right? And I think our entire debate around technology and AI really, as it's impacted every other industry, kind of does make us question what it means to be a lawyer, what it means to be a law student, what it means to have legal education, and what skills are needed in that space. And I think it does require a huge rethink about how to best serve the work that we do. I was at the conference, the Australian Academy of Law had a conference about legal education for the first time in about 30 years since the Pierce report came out, and that was 30 years ago, and that's why we have the Pre-Suite 11. And so it is almost a self-aware kind of rethink that we as a profession need to reflect on that to bring that forward.
Thank you. All right. Other questions from the floor? Yes, at the back there. Thank you.
Hi, I'm Alex Hale. I'm from Ashurst, non-lawyer, legal information professional. I guess I have a question around ethics and algorithms. So it seems like a lot of the trust of an algorithm is based on the fact that you've built it yourself. You know it, you understand how it works, and it's fine-ish. Now, I guess my question is, that's okay if you've got the support within your organisation to build it. However, the option, you're going down to the third-party route. So you're looking to buy it from Lexis, you're buying LexMac and so forth. Now, with that, the algorithm is in a black box. You don't have that visibility of the algorithm. Do you think that black box model is the primary, is one of the key barriers to wider implementation of that kind of technology, or whether the black box mentality is sustainable? Because it's a significant trust question and ethics question, but it's also a significant IP issue as well.
I actually hit the nail on the head with that twofold analysis. I do a fair bit of disciplinary law, and I think that a lawyer must be very careful when using any kind of decision-making or research tool. Now, it comes back to the professional responsibility question and whether it should be an aspect of professional responsibility to understand the tech you use. I think that question is asking about 3 or 4 questions in one. So I'm not sure that the answer is necessarily a straightforward yes or no to that. But when it comes to, do you know what legal analysis you are engaging in, and are you certain that this is your answer, your advice as a lawyer? I think it is absolutely critical from an ethical and professional responsibility point of view to know what you are doing. So I think the black box problem is a problem from that point of view. The IP problem, that's probably a little bit easier to solve because IP can be sold, but or licensed. But then we have the problem of the natural conservatism of lawyers, maybe saying, well, I don't know that I want to buy this when I don't know exactly what the rights that I'm buying are, or whether someone else maybe has the same rights. You add that to the black box problem, it's less of an ethical issue in itself, but I can see that there would be many lawyers being quite conservative about that. I always say the bar is about 10 years behind the law firms anyway, so I'm not seeing barristers pick up that kind of technology yet. It may be that it will improve before barristers do use it, but I do think we need to think very carefully about it.
So yeah, this is where I think as lawyers, with a true understanding of tech, you can really delve into those transactions to think about whether or not you want to do business with that third party. If they're going to so tightly control their IP, is it better off going with someone else? And then, you know, as a techie, I always get in and I'm sort of, as I said before, trying to reverse engineer things. So, you know, if I want to look at someone's website and see what it's built on, it's quite easy to get into the back end and sort of see what they're doing there. You know, you can get the same sort of information by user guides or various documentation that they give to you. You know, the frequently asked questions, the specifications, the project plans, and all of this kind of stuff leads you to understand what they're doing. But so, yeah, there's a commercial opportunity there, but there's also an opportunity for lawyers to sort of think different in this space and to, you know, really seek to understand what that algorithm might be doing. And if they know what the potential outcomes are, they can know where the failings might be or what's going wrong in the middle there. You know, some conversations that I have at the moment is about hacking and understanding, you know, potentially slight hacks going unnoticed for a long period of time. And I think, you know, lawyers with good tech understanding can resolve those sorts of things quicker than maybe a lay person, and you know, bridging that divide between, you know, the IT guys and lawyers or the people in the business is really important.
Can I say one very quick thing there? I think it's a really poignant question because as we see a lot of these software and this tech moving from the license model into the pay-per-use or the subscription model, we do have this balancing act we have to play between risk and cost, or ethics and a commercial decision. As lawyers, where do we sit? Give you a really good example. Ibm Watson, they can license their platform for $1 million, or you pay 1 cent per API call. So as a small business or as a small law firm, that $1 million license fee is not possible for us. So we can't look inside the black box. But we still want to provide some technology that's going to help clients. And so we go down to 1 cent per API call. So we'll see technology become more and more on this pay-per-use type of model, and that will mean that there are restrictions in what we can see and what we can't see. And I think for the software providers out there, it's going to be around transparency. So how can they provide the pay-per-use or the subscription type model, but also be transparent in what's happening under the hood?
Well said. All right, we have time probably for one more question. Gentleman in the back, thank you.
Hey, Tony Burke, I'm from Newcastle, sole practitioner and PhD candidate. I think I missed out on what the most disruptive things seem to be.
Oh, thank you for reminding me. You just get older, your working memory goes. A year ago was blockchain.
Blockchain.
Absolutely blockchain, and I was so relieved that nobody mentioned blockchain.
I think I mentioned it.
Oh, did you?
But not in that context.
The second part of the question is, Aaron, you said you thought that major disruption, significant disruption, was maybe 5 to 10 years down the track. I'm curious, either to yourself or the panel, how you describe that major disruption. Is it in relation, say, to the law firm business model, or is it in relation to the cost of legal services, or is it something different again? Thanks.
So I think it's it's unlikely to come in this way, but it could come in this way, which is the judiciary taking a particular approach, and everyone has to then take that approach as well. To my mind, and going back to blockchain, smart contracts, or at least the concept of smart contracts and how you get there, because to have a smart contract, I need to truly understand what the parties are doing and what the data is needed. So Dom and I were talking earlier about whether or not we can finally reduce a contract to a paragraph rather than 15, 20 pages, 50 pages, however long it might be. And a lot of that goes to design thinking and the human experience. Dom said he's done some research in this space, and customers don't actually like those short contracts because they don't think that they're getting any value for money. And that's similar in the insurance industry as well. I think there was some beliefs that a PDS should be reduced to 1 or 2 pages, and customers said no, and the research is saying about 15 to 20 is the best. But smart contracts, I think, are really, and this is a really complicated discussion when you get to the blockchain smart contract sort of theory. But what I'm talking about here is true input to what I call the rules of interpretation in the middle, and then true output. And doing that in a simple way via a website where you ask a simple question there and it spits out a document straight away.
Okay, thank you. Any final comments from the panel?
I would argue that we haven't seen any true disruption in the Australian market yet. We've seen a lot of innovation, but we haven't really seen true disruption. I think that will come when people from outside of the legal profession start coming in and providing legal services. That is when we all need to worry.
Well, I would also say that if you look at Singapore is a really great example for change in the legal profession. It's actually, they have complete institutional support. So the Chief Justice over there is very, very keen on making legal innovation a thing. And they've done that, or they're doing that. And that just has given it an incredible push and incredible momentum. And I think that's another kind of way of doing disruption.
Thank you, Erika. So we're going to leave it there, and I just wanted to say, I think in summary, obviously this space in AI and legal technology, you can really you can see the advancements that things have to offer. You can see the seismic shifts that are potentially there as well, but it's also quite a complex piece too. And I'd like to really thank the panel for what they shared on that. I think the complexity here really does give us questions around things like liability, bias, and fairness and equality, and in an industry where that is really what we're all about. That's that's the way that that's the foundation in which we operate. Those questions are really, really big questions. So I hope that everyone got some value out of the hour or so that we spent here today. On that note, I'd really like to thank the panelists for their contribution. Thank you so much. Also, thank you in the room, everybody, for your contribution today. We will be sending an email out to you, which has a link to some content that we'll be sending, some survey results on those kind of things. And please, by all means, stick around. I think the bar is still open. Yep, thumbs up, that's good, love that. So please stick around and tell us what you think and stick around for a conversation. Thank you so much, thank you.
Thank you.